Good morning, friends. In the series on the income tax cases, today I will discuss a very important case on section 147, 148 proceedings. The name of the case is Commissioner of Income Tax Exemptions versus BP PODDAR Foundation for Education. This case has been reported in 448 ITR at page number 695, and the matter has been decided by Calcutta High Court, and the date of the judgment is 13th September 2022. Friends, it is the basic condition for making addition under section 147 that the assessing officer must record the reasons for issuing the notice under section 148. But during the assessment proceedings, if the assessing officer feels that there is some other matters also on which the additions can be made other than those matters on which the reasons are based, then there is explanation 3 to section 147 which comes for the help of the assessing officer, because explanation 3 says that the assessing officer can make the additions on others matters also which come to the notice of the assessing officer during the course of the assessment proceedings. But my point is that explanation 3 to section 147 is not conjunctive, meaning thereby that the assessing officer can make the addition on other points only if he is able to make the addition on the main point. I explain you this with an example. For example, the notice to the assessee is issued for making some bogus purchases. But during the assessment proceedings, the assessing officer feels that the assessee has not claimed section 10A exemption properly. But during the assessment proceedings, the point of bogus purchases goes into the favor of the assessee. So in that case, he will not be able to make the addition on the section 10A exemption. If the main point on which the notice has been issued to the assessee is gone, then other matters are also gone. If the assessing officer wants to make the addition on other points, then he should issue a fresh notice to assessee under section 148 for recording the reasons for making the addition on those points. So the point is that explanation 3 to section 147 does not override the main provisions of section 147. Other points addition can be made only if the addition on the main point subsists. But in this particular case, the additions were made by the assessing officer on 2 points. One point on the basis of which the notice under section 148 was issued, and some other points also. But at the CIT appeal level also, the CIT appeal deleted the main addition on the basis of which the notice under section 148 was issued. So the point of the assessee was that if my main addition is gone, then other additions cannot subsist in the eyes of the law. Friends, this is a very important case because it throws a light on the point that the explanation to any section cannot override the main provision, because the main provision is that you have to record the reasons for the point for which you want to assess the income of the assessee. But during the assessment proceedings, if you feel that there are some other points also, you can do so. But if the main point does not exist, or that addition is deleted by CIT appeal, ITAT, High Court or Supreme Court, then the point of making the addition on other points or subsisting the addition on other points will not be valid in the eyes of the law. If you want to make the additions, then if the time persists according to section 149, the assessing officer has to record the reasons for those points, issue notice to assessee under section 148, and then you reassess. So friends, explanation 3 to section 147 is not conjunctive. The second point is that the explanation cannot override the main provisions. This is one of the best rules of interpretation of law. At the end of this video, once again, I am repeating the name of the case. The name of the case is Commissioner of Income Tax Exemption versus BP PODDAR Foundation for Education. The date of the judgment is 13 September 2022 and the matter has been reported in 448 ITR at page number 695. The matter has been decided by Calcutta High Court. Thank you, friends.